focus of this video is on the Consumer Rights Directive, one of the consumer contract law directives that has been promulgated by the European Union. In Article 1 of the directive, we already see the main purpose of the directive is to facilitate the proper functioning of the internal market. Now, the way in which this directive aims to facilitate the proper functioning of the internal market is to provide a high level of consumer protection. This directive is of a mandatory nature, and we see this in Article 3, Paragraph 1 of the directive. It tells us that this directive shall apply under the conditions and to the extent set out in its provisions to any contract concluded between a trader and a consumer. Now, we'll look further into the actual scope of the directive, but it's important at this stage to note that that the rules that are laid down are mandatory rules, and they cannot be derogated from to the detriment of the consumer. We also see in Article 4 that the member states who are under the obligation to implement this directive into their national law are may not provide provisions that offer consumers a higher or a lower level of protection than that is provided by the directive itself. So in this sense, we refer to the directive, the Consumer Rights Directive, as being a directive of maximum harmonization. So there is no possibility for member states to go above or below the level of harmonization that is laid down in this directive. This in contrast to some directives that had been promulgated prior to the Consumer Rights Directive in 2011. These directives were often of a minimum harmonization character, which meant that member states were free to provide a level of protection to consumers that went above the level that was provided by this directive. But with the Consumer Rights Directive, we see that the EU is moving towards maximum harmonization, so that there is sort of a high threshold of consumer protection that is available to consumers who are buying goods and services in the European Union. That being said, although the member states may not in their legislation go above the protection that's provided by the directive, Article 3, Paragraph 6 tells us that traders are not prevented from offering consumers contractual arrangements that go beyond the protection that's offered in the directive. So businesses, traders do have the possibility to compete for consumers by providing them with an even higher level of protection than what is laid down in law. What they obviously cannot do is to go below the level that is set in mandatory law as reflected in this Consumer Rights Directive. We're going to be focusing on the provisions of the directive, and during this video I'm going to take you through it step by step. It's important to recognize, however, that the directive itself is not the primary source or the direct source of the rights and obligations that are laid down. As a directive, the member states are under an obligation to implement the rules that are laid down in the directive into their national legislation. So the instrument of a directive offers member states the possibility to decide how best to implement the consumer protection that is laid down in this directive into their national legislations. This in contrast to an EU regulation, which would be directly applicable and doesn't require any implementing legislation on the part of the national member states or the national legislator of the member states. So although we're going to be looking throughout this course directly at the directives and the provisions that the directives in EU law contain, or the provisions that are contained in EU law directives, it's important to recognize that in practice the legal provisions are to be found in the national codifications and statutes, and those are the provisions on which a consumer would be able to rely on in any legal proceedings. So let's take a closer look at the Consumer Rights Directive and find out when it is applicable. For that purpose, we need to take a look at Article 3 of the Directive. And in Article 3, Paragraph 1, it tells us that the Directive shall apply. And so here we see the indicator of the fact that the Directive is of a mandatory character. And the Directive shall apply under the conditions and to the extent set out in these provisions to any contract concluded between a trader and a consumer. Now, Article 3 furthermore goes on to explain what types of contracts are excluded from the scope of this directive, but primarily the directive is applicable to any contract that is concluded between a trader and a consumer. Now, to further understand what that means with respect to what types of contracts are included under this directive, we need to take a look back at Article 2 of the directive, which provides us with a number of definitions. And so the first thing that we need to establish is whether we are dealing with a contract between a trader and a consumer. And Article 2, Paragraph 2, defines for us what is a trader. And here it tells us that a trader means any natural person or any legal person, irrespective of whether privately or publicly owned, who is acting, including through any other person acting in his name or on his behalf, for purposes related to his trade, business, craft, or profession, in relation to the contracts covered by this directive. So the first thing that we need to see is whether or not one of the contracting parties involved falls within this definition of a trader. Are they acting for purposes relating to their trade, business, craft, or profession? Now, the second party in the contract is the consumer. So we need to understand whether or not the person contracting with the trader can be classified as a consumer. And in order to understand this, we need to take a look at Article 2, Paragraph 1, which tells us that a consumer means any natural person who, in contracts covered by this directive, is acting for purposes which are outside of his trade, business, craft, or profession. So we see that this is a classic B2C situation, business to consumer contract, whereby the trader, one party, the business, has to be contracting for the purpose of their trade, business, craft, or profession, and the other one, the consumer, is acting outside of that scope. So if we take a look at Article 3, Paragraph 1, we see that the directive applies to any contract that is made between a trader and a consumer. That being said, if we go further into the directive and look at some of its provisions, we see that some of them apply to specific types of contracts that are made between traders and consumers. Specific types in the sense of the way in which the contract has come about or where it has been made. And certain provisions are therefore laid down in this directive for contracts that are made at a distance. For instance, when we are concluding online contracts with an online provider of goods, for instance, or where contracts are made at the doorstep, where we have a person who is selling goods or services who goes from door to door, and these are what we refer to as off-premises contracts. Now, in order to know which provision deals with which type of contract, we need to be able to define these different types of contracts. And here again, Article 2 and the definitions that are provided in that in Article 2 give us an indication of what is a distance contract and what is an off-premises contract. So a distance contract is further defined in Article 2, Paragraph 7 as meaning a contract concluded between a trader and a consumer under an organized distance sales or service provision scheme without the simultaneous physical presence of the trader and the consumer. And it's been made with the exclusive use of one or more means of distance communication up to and including the time at which the contract is concluded. So here we see that there is a specific definition of what is a distance contract, which will be relevant for determining what are the information duties that the trader has, as well as the right to be able to withdraw under the directive. Article 2, Paragraph 8 further defines what an off-premises contract is. And it's essentially means that we do have the simultaneous physical presence of the trader and the consumer. However, it's at a place that is not the business premises of the trader. And in order to understand then what the business premises of the trader is, we look further down into Article 2, Paragraph 9, which further defines the concept of a business premise, of business premises. So in order to determine to what extent the directive applies and which provisions in the directive applies, it's very important to continue to refer to the definitions that are provided in Article 2. So what is it that the Consumer Rights Directive actually does? Well, if we take a look at the provisions of the Consumer Rights Directive, we see that it has two main topics or subject matter that it is dealing with. On the one hand, it contains a number of provisions relating to information duties, so the duty of the trader to provide the consumer with information. And the other important aspect of the Consumer Rights Directive is that it offers the consumer a right to withdraw from the contract after it has been concluded. Now we're going to take a look at both of these aspects in the Consumer Rights Directive.